A man is beaten in Delhi. He wants to sue. A suit over land in Delhi is instead filed in a Mumbai court. A shopkeeper wants to recover 50,000 rupees for unpaid work. Can he walk into the High Court and demand it be heard today? A 5 crore claim lands on the desk of a judge who can only hear cases up to 50 lakh. A divorce petition is dropped, by mistake, into a consumer commission. None of these cases get heard as filed, not because the facts are wrong, not because the law is silent, but because of one question that has to be answered before any other question is even allowed to be asked. Jurisdiction. Which court is this? Today, we answer that completely. Introduction. Every legal system has to answer one quiet question before it answers anything else. Who gets to decide? Not what the law says about right and wrong, just which room, which bench, which court gets to open the file at all. That's what we're spending this episode on. I'm the narrator. I'll hold the thread and keep asking the obvious question until it stops being obvious. Let's meet the other 3 voices doing this with me.
I'm the scholar. I spend my time on where legal ideas come from, why a system built the way it did, and what that choice says about the country that made it. Jurisdiction looks like plumbing from the outside. But it's actually one of the oldest questions in law. How do you divide authority across a country this size, without either overwhelming one court or leaving another with nothing to check it?
I'm the practitioner. I've filed cases, and I've had cases thrown out over exactly this question before a single argument on the merits was ever heard. Get jurisdiction wrong, and it doesn't matter how strong your case is. The court simply will not open the door. The scholar studies the map. I've had to walk it, sometimes twice, when I got the first turn wrong.
And I'm the analyst. I look at law as a system of limits and switches. What triggers which court, what closes a door, what happens when 2 doors both seem to fit. Today we're taking apart the Code of Civil Procedure, 1908, specifically how it decides jurisdiction. Section 3, the different kinds of limits, and a structural quirk that separates civil courts from criminal ones entirely, piece by piece.
4 ways of looking at the same question. So, where does a court's authority actually come from, and where does it run out? Let's start at the beginning. Part 1. What jurisdiction actually means. The Code of Civil Procedure, 1908, is not a small document. Analyst, give us the shape of it before we go into the substance.
The code has 158 sections in total, and those sections establish the jurisdiction and the broad powers of the courts. Alongside that, there is one schedule containing 51 orders, and those orders break the whole thing down into the detailed, practical rules for how a civil lawsuit actually gets conducted. The sections give you the authority. The orders give you the mechanics.
And there isn't just one civil court in India. Scholar, where does that start?
It starts with the simple fact that India has many courts, not one. And Section 3 of the Code of Civil Procedure is where that structure is first set out for civil matters. But before you can even talk about which specific court, you have to understand what courts do in the first place. At the most basic level, a court's job is to adjudicate, to hear, and decide matters of every kind that come before it. But that power is never unlimited. There is always a boundary drawn around it.
And that boundary is what the word jurisdiction actually means. It is the authority of a court to deal with the matters that come before it for adjudication, which means a court will only take up a case in 2 situations. First, the matter has actually been brought before it for a decision. Second, that matter falls within the limits of that court's jurisdiction. step outside either of those, and the court simply does not have the authority to touch it.
There's a theoretical third category, worth naming precisely because it's rare. A court with no limit at all on its jurisdiction would have what's called unlimited jurisdiction. But in practice, that almost never exists. There is nearly always a limit set somewhere, by subject, by geography, by the value of the claim, or by some combination of all three. Unlimited jurisdiction is the exception people learn about mostly to understand why it isn't the rule.
Part 2. How the limit gets set. So if every court has a boundary, who draws that boundary and how?
There are three ways a limit gets set. First, by a charter limit set by the Indian government. Second, by a statute, a law that fixes the limit directly. Third, by a commission set up by the government, where that commission itself sets off the limit. Three different sources, same underlying purpose, telling a court exactly how far its authority reaches.
And once you have a real dispute, what the law calls a cause of action, that dispute produces a case, and inside that case, there is what's called the matter in issue. That matter in issue always has a specific nature to it. It might be about property, about money, about a contract, about an injury. And it is that specific nature which decides which court is the related court, the one actually empowered to hear it.
So the practical question becomes, how do you find that related court? The related court is simply the court that has jurisdiction to deal with that specific nature of case. And here's the part that catches people out. A court can and does say no. It can refuse to accept a matter on the ground that the matter is out of its jurisdiction entirely. That refusal isn't the court being difficult. It's the court respecting its own boundary.
Part 3. The kinds of limits, subject matter and place of suing. Let's get specific. What are the actual kinds of limits placed on a civil court?
There are several, and they can stack on top of each other. Jurisdiction over subject matter, place of suing, jurisdiction over the person, pecuniary jurisdiction, meaning the value of the claim, and jurisdiction, depending on the powers of the court itself. A single case can be tested against all five before it even reaches its first hearing on the merits.
Take subject matter first, because it's the most intuitive one. A small cause court is a good example. It handles matters related to promissory notes and matters related to money owed for work done. The limit here is set by statute. The law itself decides what kind of dispute this particular kind of court is built to handle. Bring it the wrong subject, and it isn't equipped to take it, regardless of how small or simple the dispute might seem.
Now, place of suing, this is the one I've actually had to argue in practice. Take the simple version first. Two parties, same location, say both in Delhi. Person A beats person B. That's a single same territorial jurisdiction. One obvious court. Now change one fact. Person A is from Delhi and person B is from Uttar Pradesh. The same kind of incident now sits across two different territorial jurisdictions. And person B, the one who was wronged, actually gets a choice. They can file the case in Uttar Pradesh or they can file it in Delhi.
That's territorial jurisdiction functioning exactly as designed. The limit is fixed by government, and it defines the authority of courts to decide cases according to where those cases geographically belong. When both parties and the incident sit inside one territory, there's no ambiguity. When they don't, the law doesn't leave you stranded. It gives the aggrieved party a real choice of forum. Rather than forcing the dispute into a single fixed address.
Part 4. Person, money, and power. The remaining limits. We've covered subject and place. What about the person being sued and the money involved?
Jurisdiction over the person is broad by default. Courts can take up cases against any type of person, but there's one important exception built in, where the matter involves a foreign state or a representative of a foreign state. The court can only handle that case with the permission of the central government. That single carve-out reflects something bigger than procedure. Sovereignty and diplomacy, reaching directly into the machinery of a civil court.
Then there's pecuniary jurisdiction. Jurisdiction determined by the monetary value of the subject matter of the suit. A court can hear only those cases that fall within the pecuniary limits prescribed for it by law. The Consumer Protection Act offers a simple illustration. Consumer disputes are allocated among the district, state, and national commissions based on the value involved. In civil courts, too, pecuniary limits help determine which court will hear a suit. These limits are fixed by the applicable law and can vary depending on the court and the state. In short, when deciding whether a court has jurisdiction, it's not enough to ask where the dispute arose. You also have to ask how much the dispute is worth.
And the final limit is about the court's own powers. Specifically, whether it's hearing a matter for the first time or hearing it on appeal. Original jurisdiction is straightforward. A case comes to a subordinate court for the very first time, and if the parties aren't satisfied with that outcome, the next step is an appeal. That second step is appellate jurisdiction. And here's a detail worth holding on to. The district court, the high court, and the Supreme Court each carry both powers at once. They can hear a matter fresh, as original jurisdiction, and they can hear it again, as an appeal from a lower forum. The same court, wearing two different hats depending on how the case arrived at its door.
Part 5. Why civil courts don't look like criminal courts. Now here's a structural question that a lot of people never think to ask. Why does the criminal court system look so uniform across the country, while the civil court system doesn't?
This is genuinely one of the more elegant design choices in Indian law. Criminal law is closely tied to the state's sovereign power to prosecute offenses. Because of that, Parliament built a relatively uniform court structure for criminal matters across the entire country. That's the logic behind the BNSS, the Code of Criminal Procedure Law. The Code of Civil Procedure has a completely different purpose. It is only a procedural code for civil litigation. It doesn't create the courts. It assumes civil courts already exist under the relevant state law, and it simply tells them how to proceed once a case lands in front of them.
And that assumption has real, visible consequences even today. Historically, civil courts varied significantly among the different provinces and princely states. There was never one single template, and that variation hasn't disappeared. States today may set different pecuniary limits from each other. They may organize their subordinate civil courts differently. Some states use entirely different designations, or hand their courts different jurisdictions altogether. Because of all that variation, the CPC deliberately leaves the actual establishment and classification of civil courts to the State Civil Courts Acts. It builds the procedure. It leaves the architecture to the states.
That's not a gap in the code. It's a decision built into the code. The classification and designation of subordinate civil judges is a matter of state law, not something the CPC itself decides. Concretely, the Code of Civil Procedure, 1908, does not create civil courts. It only assumes they exist, and then prescribes their jurisdiction and their procedure. And it does not classify judges as junior division or senior division either. That labeling comes from somewhere else entirely.
Part 6, where the architecture actually leaves. So if the CPC doesn't build the courts or classify the judges, who does?
Each state enacts its own Civil Courts Act, and that act is where the real architecture of the civil court system is laid down. It defines the different classes of civil courts within the state. It provides for their constitution, how they are established. It prescribes their pecuniary jurisdiction, the monetary value of cases they can hear. It determines how appeals move through the state's civil court hierarchy, and it lays down the administrative structure that ties the entire system together. In other words, while the CPC provides the procedural framework for civil litigation, the institutional structure of the civil courts is largely governed by state law.
And Maharashtra state gives us a concrete working example of exactly that. For Maharashtra state, this architecture is laid out by the Maharashtra Civil Courts Act, specifically Section 24 and Section 25. That's a state-specific statute doing exactly the job the CPC deliberately left open, building the actual court structure, while the CPC continues to govern how a case moves once it's inside that structure. Two different laws, two different jobs, working on the same case at the same time.
Which is exactly why, before I ever look at the strength of a client's case, I look at where it has to be filed, subject matter, territory, pecuniary value, the state act governing that particular court. Get any one of those wrong, and the merits of the case never even get discussed.
A closing. What stays with me about jurisdiction is how unglamorous it looks, and how much weight it quietly carries. It never asks who's right. It only asks who gets to decide. And a country as large and as varied as India needed an answer that could flex by subject, by place, by value, without ever losing its shape.
And from where I sit, that flexibility is the whole practice. Every filing starts with the same quiet check. Is this the right door? Not the right argument yet, just the right door. Everything else waits until that question is settled.
Which is what makes the system genuinely well designed. It doesn't force one uniform court onto a country full of different histories and different states. It sets the rules of the road nationally through the CPC, and it lets the states build the actual roads themselves. That's not a weakness in the framework. That's the framework working exactly as intended.
A shared house in Delhi, a dispute stretched across 2 states, a claim worth 5,000 rupees and a claim worth 10 crore. The law doesn't send all 3 to the same room. It asks where, what kind, and how much before it ever asks who's right, because before a single argument can be heard, someone first has to open the door. Thank you for listening.